Hello and welcome to Byjus Exam Prep. Welcome to another episode of our knowledge series. Over the last 2 weeks, we've been holding live sessions every day at 10 a.m. and 3 p.m. And the intention is to help you cover 100 important static topics for your prelims and your mains. The program is designed to help those aspirants who are preparing for this year's mains and as well as for the 2023 aspirants who are preparing for both prelims and mains. So if you're benefiting from the initiative, do let us know by liking the video, share the video with fellow aspirants, and don't forget to hit the subscribe button. So let's start with today's discussion, and we are going to talk about the Wildlife Protection Act of 1972, which is a very important topic under Environment and Ecology. This legislation, that is the Wildlife Protection Act of 1972, it is meant for protecting India's biodiversity. When I say biodiversity, it specifically deals with the protection of India's wild animals, birds and plant species, especially those which are endangered. So it provides for protection of India's flora and fauna and provides for the establishment of protected areas such as wildlife sanctuaries, national parks, tiger reserves, etc. So it's a very, very important piece of legislation in the field of environmental law, and it plays a critical role in the protection of India's endangered biodiversity. So in this session, we are going to understand all the key points related to the Wildlife Protection Act. We'll take a look at the constitutional framework, we'll discuss the historical perspective, we'll evaluate the important provisions of the Act, and also talk about some recent developments regarding an amendment bill that seeks to amend the Wildlife Protection Act. So let's start by talking about the constitutional framework in India with regard to wildlife protection. See, the Indian Constitution does provide enough focus and attention on the topic of environment and biodiversity protection. For example, if you look at Article 21, which is a fundamental right that guarantees right to life, this fundamental right has been interpreted widely by various court rulings. Through this wide interpretation of Article 21, right to live has been interpreted by the court, by the Supreme Court, to include the right to live in a clean and healthy environment. So this naturally includes the protection of our biodiversity, the protection of our flora and fauna as well. Because the balance in the biodiversity is what determines the ecological balance, the health of the ecosystems, and that in turn guarantees the right to live in a clean and healthy environment. Apart from this, we also have Article 48A of DPSP, the Directive Principles of State Policy, which places an obligation on the state, that is on the government, to protect and conserve the environment and to safeguard forest and wildlife. Then we also have a fundamental duty under Article 51A Clause G that places a non-binding obligation on the citizens. The citizens of the country, we the citizens of the country have an obligation to protect the forests, wildlife and our natural resources. That includes the flora and fauna, especially the endangered flora and fauna. Then if you look at 42nd Constitutional Amendment Act of 1976, which is referred to as a mini constitution in itself, it placed the subject of forest and protection of wildlife and birds on the concurrent list. Before this, the subject of forest was under the state list. So by placing forests and even protection of wildlife and birds on the concurrent list of the 7th schedule, it became the joint responsibility of the central government and the state governments to ensure the protection of India's wildlife. So when we say India's wildlife, we are referring to India's wild animals, the birds, the plant species, which essentially constitute our biodiversity. As you know, India is a country that is blessed with a very rich biodiversity, and at the same time, India's biodiversity faces a number of threats. If you look at the historical approach towards wildlife protection in India, during the colonial times, there wasn't much attention or much focus given on wildlife protection. There were a couple of laws introduced by the British, but they weren't effective enough. Because during the colonial times, hunting and poaching was widely encouraged by the British Raj itself. There were a few laws like the Wild Birds Protection Act of 1887, that sought to prohibit the possession and sale of specified wild birds. Then later, in 1912, Wild Birds and Animal Protection Act was also introduced. These were two colonial era legislations which were designed to protect the wildlife of India. But both were very ineffective in tackling the threat of hunting and poaching. Because during the British Raj, there was no genuine focus or priority given for wildlife conservation and wildlife protection. In fact, hunting was encouraged by the British Raj as well, along with the princely states, the princely kingdoms, and as a result, there was widespread hunting and poaching as part of the games or game-based hunting that was widely practiced across India. So during this period, there was large-scale destruction of India's endangered species, and we can conclude that during the colonial period, there wasn't enough attention paid or enough priority given for wildlife protection and conservation. Even after independence, India was still focused on basic issues like food, hunger, growth, industrial development, etc. In the 1950s, enough attention wasn't being paid to environmental issues. But this is when a global movement had started, which started paying more attention towards environmental issues. In 1972, we had the Stockholm Conference. The Stockholm Conference prioritized the focus on environment conservation and environment protection. By 1960s, India also started realizing that industrial growth and development and widespread cultivation and agriculture could threaten our forests and wildlife. So by late 1960s, there was a consciousness that was building up in India and around the world with regard to wildlife protection and conservation. It was in this context that India enacted, the Indian Parliament enacted the Wildlife Protection Act of 1972. This was one of the first major pieces of legislation that dealt with environmental issues, and it provides for protection of India's wildlife. It has provisions to protect India's wild animals, birds and plants. It mainly focuses on the endangered, the threatened species, and also provides for the establishment of protected areas. Protected areas like wildlife sanctuaries, national parks, etc. can be set up under the provisions of this particular act. Before this act was enacted, India had only 5 national parks, because there wasn't much focus being given to establishment of such protected areas where the wild animals and birds could be protected. But today, we have more than 100 national parks in the country, right? There are plenty of wildlife sanctuaries. We have many biosphere reserves. We have plenty of tiger reserves. So these protected areas, most of it, they owe their origin, they owe their establishment to the provisions of the Wildlife Protection Act. It is this legislation which enables the establishment of these protected areas. See, what the Act does is that it provides for establishment of a few wildlife advisory boards. We are going to discuss them a little while later. It also recognizes the roles and functions of authorities such as wildlife wardens and places certain duties on them so that they are responsible for guarding and protecting India's wildlife. These protected areas are administered through wildlife wardens, and the responsibility over here is shared by both the central and the state governments, as the subject is on the concurrent list. It was this law which helped India to become a party to the CITES Convention. The CITES Convention are also called as the Washington Convention. It stands for Convention on International Trade in Endangered Species of Wild Fauna and Flora. This convention, it regulates the trade of endangered species, endangered plants and animals. So India became a party to this convention, and we are abiding by the terms of the convention that is helping us in tackling hunting, poaching and trade of endangered species. So this legislation enabled India to become a party to this important international convention, and for the first time it helped India create a list of endangered wildlife species of India. Because under this act, we have schedules under which the animals, birds and plants are listed and segregated depending on the threat level that they face. They are accorded varying degrees of protection depending on the schedule in which these wild these wildlife are placed, and this is what allows for a structured mechanism, a structured legal institutional mechanism through which we can protect and conserve India's wildlife. So we're going to take a more detailed look at some of these salient features of the Wildlife Protection Act. See, the Act basically prohibited hunting and poaching of endangered species. Please make a note of this point. It prohibits the hunting and poaching of endangered species, and scheduled animals are prohibited from being traded as per the provisions of this Act. It not only places a ban on hunting and poaching, but it also prohibits the trade of endangered species and their body parts. Because hunters and poachers, they are behind the body parts of certain animals. For example, the tusks of elephant, the nails or the skin of big cats like tigers, leopards, etc., right? Or the horn of the rhinoceros. So to put an end to such hunting and poaching and to prohibit the trade of such body parts of endangered species which are hunted and poached, the legislation brought out very stringent provisions. This is a criminal offense. Hunting and poaching becomes a criminal offense, and anyone who enables these acts will be prosecuted, will be punished with very strict punishments. The Act also provides for license. It provides for the issuance of licenses to sell, transfer, and possess some of the designated wildlife species. A few wildlife species, like let's say elephants. Elephants can be bred in captivity as well for religious purposes. So certain species of animals, certain species of birds, they can be sold, you can trade, you can transfer them, you can possess them as well, but you need to obtain the required licenses from the concerned authorities. So even those provisions have been outlined under the Wildlife Protection Act. Then, as I pointed out, it provides for a few provisions for establishment of protected areas in India. Later, I'm going to explain how these protected areas are set up and what exactly is the difference between a wildlife sanctuary and a national park. Then, more importantly, the Wildlife Protection Act was amended several times over the years, and through one such amendment, it provided for the establishment of the Central Zoo Authority. The Central Zoo Authority is the nodal agency responsible for management and administration of all the zoos in India, the zoological parks in India. So this authority was set up in 1992. So basically, the Wildlife Protection Act has enabled the establishment of key institutions. We are going to discuss a few more institutions which have been created as a result of this act. So one such institution which has been set up through the Wildlife Protection Act is the Central Zoo Authority, which has administrative powers and managerial powers over the zoological parks of India. Now, coming to the various schedules under Wildlife Protection Act, in the current form, there are 6 schedules. We have Schedule 1, 2, 3, 4, 5, and 6. The wildlife of India, the animals, the birds, and the plant species, they are categorized and segregated under these schedules, and they provide for varying degrees of protection. The most threatened species, the most endangered species, they are listed under Schedule 1 and Schedule 2. Schedule 1 species, they get the highest degree of protection. All the endangered species like tigers, leopards, the Himalayan brown bear, Indian gazelle, clouded leopard, etc. The list goes on. There's an entire list of Schedule 1 animals which are considered as endangered species of India. These are the most threatened species of animals and birds. They face the highest risk from hunting and poaching. So they're all listed under Schedule 1 and they enjoy the highest degree of protection. So obviously, hunting and poaching of these species, it is completely prohibited, and if anyone violates the law, they will be prosecuted and they are provided with a strict punishment. It is a criminal offense. Even Schedule 2 has a list of animals which are accorded a high degree of protection, but these are the species which face a slightly lower degree of threat. Under Schedule 2, there is Part 2. So under Part 2 of Schedule 2, there are certain species of animals and birds that are listed, and they again enjoy a high degree of protection, but they enjoy a slightly lower degree of protection as compared to Schedule 1 species, because the threat level they face is slightly lower as compared to the species listed under Schedule 1. So to simplify things, animals and birds listed under Schedule 1 and Schedule 2, they enjoy the highest degree of protection. Then comes Schedule 3 and 4, where species that are not endangered, they are listed over here. Species which don't face a major threat, they are listed over here. For example, the hyena, the Malabar tree toad, Himalayan rats, porcupines, etc. So the hunting and poaching of these animals is also prohibited, but the punishment, the penalties are slightly lower. When compared to Schedule 1 and Schedule 2 species, the punishment and the penalties given are lower under Schedule 3 and Schedule 4, because these species of animals and birds, they are not endangered, they are not threatened. So the highest degree of protection is reserved for Schedule 1 and Part 2 of Schedule 2 species. Then we have Schedule 5 that deals with vermins, or what we call as pests. Pests such as rats, mice, crows, fruit bats, etc. These are a threat to agriculture. These are a threat to human health. These are a threat to the ecosystem itself if their population explodes. So these vermins and pests, they can be eliminated, they can be hunted under the provisions of Schedule 5. It also provides for the hunting of certain designated species of animals, right? Trophy hunting, however, in India is not recognized. Trophy hunting or game-based hunting is not recognized, but certain categories of hunting which is needed to deal with a threat is authorized under Schedule 5. See, sometimes even a Schedule 1 or Schedule 2 animal or bird can be hunted if the required permission is obtained from the authorities. But permission is given only on certain grounds. For example, if there is a man-eating tiger which is attacking humans repeatedly, right? So only in such special cases, only when the animal cannot be captured alive, only in certain special conditions, or let's say if the animal is facing a life-threatening disease, so to end its suffering and misery, only in such special circumstances, authorities might give permission to hunt or to kill an endangered species. Otherwise, hunting and killing of these animals is entirely prohibited under Schedule 1 and Schedule 2. So they have the highest degree of protection. In Schedule 3 and Schedule 4, you have animals and species which are not so endangered, but even their hunting is prohibited. And then under Schedule 5, we have vermins, pests, and few categories of species where hunting might be allowed depending on the permissions that are obtained. Then finally, the last schedule, Schedule number 6. This schedule is dedicated for plant species. Please note down this point. Schedule 1 to 5 dealt with animals and birds, wild animals and birds. Whereas Schedule 6, on the other hand, it exclusively deals with plant species that are forbidden from cultivation, and their harvesting is also prohibited. So this is how the Wildlife Protection Act ensures the protection and survival of India's wildlife. It has categorized the species into different categories based on the threat level, places different restrictions and prohibitions on their hunting, poaching and trade, and this provides for a legal and institutional mechanism through which our wildlife can be protected. So it also provides for establishment of many institutions and authorities. We already discussed how it provided for the establishment of Central Zoo Authority. Along with that, it has also provided for the establishment of the National Board for Wildlife. The NBW, it's a key institution, it's an apex body with regard to management of our protected areas. The National Board for Wildlife, it is headed by the Prime Minister of India himself. Is that clear? The Prime Minister is the chairperson of the National Board for Wildlife. It is this advisory board, it is this Wildlife Advisory Board which takes all the key policy decisions regarding the management and administration of India's protected areas. That is our sanctuaries, national parks, biosphere reserves, tiger reserves, etc. So it is this act that has provided for the establishment of this Wildlife Advisory Body which is headed by the Prime Minister. Then even the NTCA, the National Tiger Conservation Authority, that has been set up under Project Tiger to protect tigers and to maintain and manage the tiger reserves of India. This authority also draws its legal backing from the Wildlife Protection Act. So please note down that under Wildlife Protection Act, three major institutions have been created. One is the Central Zoo Authority, second is the National Board for Wildlife headed by the Prime Minister, and third is the NTCA, the National Tiger Conservation Authority. So these bodies, they play a key role in the protection of India's wildlife. And as I mentioned earlier, the Act also provides for the establishment of India's protected areas. That is, it provides for the establishment of sanctuaries, that is wildlife sanctuaries and bird sanctuaries. In fact, both state governments and central governments, they have the powers to initiate the process of establishing a wildlife sanctuary. They can bring out a notification declaring the intention to constitute a natural area, a naturally significant area for biodiversity. They can designate such a naturally significant area as a wildlife sanctuary, right? These are not artificial parks or sanctuaries that are created. It's not like a zoological park or a botanical park. These are natural habitats. These are natural habitats which are rich in biodiversity, where certain threatened and endangered species of animals, plants and birds are present. So the state government or the center can take the lead. They can take the initiative and issue the notification to signal an intention to set up such a protected area. So this process takes some time, because it involves extensive consultation between center and state, with local communities and with all the other concerned stakeholders. Once the consultation process is completed, finally the state or the center can go ahead to establish the wildlife sanctuaries and the bird sanctuaries, right? So in a sanctuary, widespread protection is guaranteed to all the species that are present within the protected area. Of course, hunting is prohibited in a sanctuary. Hunting of any wildlife is entirely prohibited. Even human activity inside a sanctuary is restricted. Please remember this. Very limited human activity might be allowed. For example, if there are tribal communities living near a sanctuary, they might be allowed their traditional rights like collection of minor forest produce. They can collect only basic forest produce, but they can't take up extensive agriculture and cultivation. They might be given the right to graze their cattle. Cattle grazing might be allowed. So human activity might be allowed in a sanctuary on a case-to-case basis. But otherwise, there are a lot of restrictions placed on human activity, and industrial development, expansion of agriculture is completely prohibited, right? Hunting is entirely prohibited. So these protected areas, they provide for the protection of these endangered species that are present in these designated reserves, in these designated areas. Then we have national parks which have a higher degree of protection as compared to sanctuaries. Before the Act, like I said, we only had 5 national parks in India. Today there are more than 100. So again, state or central government can take the initiative. They can initiate the process of establishing a national park, either by merging few existing sanctuaries or by identifying an entirely new habitat. So the state and the center will work together, and they have to get the approval of the National Board for Wildlife. National parks cannot be set up without the recommendations of the National Board for Wildlife. In national parks, very high degree of protection is given. It is an area which has more protection and more restrictions than wildlife sanctuaries. Here hunting is entirely prohibited and human activity is not allowed. If there are settlements in these areas, let's say if there are forest dwellers or tribal communities, they might be rehabilitated. They might be brought out of the protected area and they might be resettled outside of the core area. So national parks enjoy a higher degree of protection as compared to wildlife sanctuaries. So these are some important protected areas that are set up in India under the provisions of this Act. The Act also provides for establishment of conservation reserves. This right lies with the state government itself. Conservation reserves are like buffer zones around existing protected areas. For example, if there is a ecologically important area present around a sanctuary or a national park, those important patches, those important habitats can be designated as a conservation reserve. It helps in creating a cushion around existing sanctuaries and national parks. So state governments have the power to constitute a conservation reserve management committee which will be responsible for management and protection of these conservation areas. So they basically come up around a national park or around a wildlife sanctuary. So small part of these important ecosystems can be recognized by the state government as a conservation reserve. It acts like a buffer zone to protect the core areas inside the national parks and sanctuaries. Then you also have community reserves, where the state government can designate even private land or community-owned land for conservation purposes. Let's say there is a private piece of land or a land which is owned by a community. If it is important for conservation, if it is playing a role in the protection of the endangered species in a national park or a sanctuary, those community lands can also be designated as a community reserve. Here, the government will work with the local community, take their approval, and it will set up a community reserve management committee so that the local people, the local communities will be responsible for protection and conservation of these community reserves. So this provides for a grassroots approach where the local communities are also involved in the conservation efforts, especially tribal communities and forest dwelling communities. They play a key role in conservation, and the Wildlife Protection Act provides a provision for that. Then it also provides for setting up of tiger reserves under Project Tiger. Project Tiger is a very important conservation program of the Government of India. It is administered by the NTCA, the National Tiger Conservation Authority, right? So tiger reserves are also set up under the provisions of this act. So now that you are aware of the key provisions, the salient features of the act, we are going to end the discussion by talking about a recent development. Recently, the government has proposed an amendment to this act. See, the Wildlife Protection Act has been amended several times over the years. It is through these amendments that the act has been made better. It has been revised and upgraded to plug the gaps that exist in wildlife protection. So recently, the Government of India has introduced a bill in the Parliament. It was introduced in December 2021 in the Lok Sabha. Now the bill has been referred to a standing committee, to a parliamentary standing committee, and recently in April it has submitted its report. Now that is why the amendment bill is also important for your exams. You should know what are the key proposals made by the government in this amendment bill. The government has proposed to provide for more provisions to implement the CITES Convention in India. Like I said, the CITES Convention is very crucial. It is important to regulate the trade of endangered species. Even though India is a party to it, even though India has been implementing the CITES Convention, there have been certain gaps in tackling, hunting, poaching, and trafficking of wildlife products. So to effectively curb this threat, India wants to implement a few provisions to ensure that we have a stringent mechanism to regulate the trade of wildlife products and threatened species. Is that clear? The amendment bill proposes the establishment of a management committee and a scientific committee. According to the provisions of the amendment bill, a management committee and a scientific committee will be set up. They will review as to how the trade of endangered species and their products has to be regulated in the country. They will give case-to-case approvals and licenses for trading endangered species and their wildlife products. So India wants to abide by the CITES Convention. We want to scale up our standards, and this amendment bill has important provisions in this regard. Then it provides for rationalizing the schedules that we discussed. I mentioned earlier that there were 6 schedules as of now. Now the government has proposed this is ineffective, it is outdated. So the government wants to revise, rationalize and update this and bring down the 6 schedules to just 4 well-organized schedules. The government wants to merge Schedule 1 and Schedule 2 into just one single schedule so that all endangered species that require protection are placed under Schedule 1. So if this bill is enacted, they will enjoy the highest degree of protection. That is, all Schedule 1 species, they will get the highest degree of protection. The existing Schedule 3 and Schedule 4, they will be merged into Schedule number 2, which will have a lesser degree, a lower degree of protection. Then remember, we spoke about existing Schedule 6 that deals exclusively with plant species. That will be converted into Schedule number 3. Schedule 3 will deal with plant species henceforth once the amendment bill is enacted. Then Schedule 5 that we spoke about, that deals with vermins and pests, it is being removed. This schedule dealing with vermins and pests will be removed entirely, and instead a new schedule is being introduced, which would be the 4th schedule, that will contain few species that are listed under the CITES Convention. Under the CITES Convention, you have these appendices, Appendix 1, Appendix 2, etc. They enjoy varying degrees of protection with regard to trade of endangered species and their products. So those species listed by CITES, they will be listed separately under Schedule 4 so that India can strictly abide by the terms of the CITES Convention. So that is a very, very important amendment that has been proposed. The amendment also deals with invasive alien species that can pose a threat to our ecosystems. See, invasive alien species, they refer to plants or animals that are not native to India. They don't belong to our native ecosystems. They might be imported from outside. And there are chances that certain alien species which are coming from the outside, they might expand exponentially. They might take over our native ecosystems and threaten the existing flora and fauna. There have been many invasive alien species that have threatened biodiversity. So to regulate the entry of invasive alien species, the amendment bill has certain provisions, and the central government will acquire more powers to regulate and prohibit the import, trade, possession and proliferation of such invasive alien species. Concerned authorities or designated authorities, they will be given additional powers to seize and dispose any such invasive alien species which might enter the Indian ecosystem. Along with that, it will give greater control over wildlife sanctuaries and their regulation and management. The amendment bill proposes to provide specified powers to the Chief Wildlife Warden, who is responsible for the administration and management of the protected areas. The Chief Wildlife Warden is appointed by the state governments. His roles, duties and responsibilities are defined by the Wildlife Protection Act. Through the amendment, the role is being modified to give him more powers, additional powers, and to ensure that the Wildlife Warden functions in a manner in which that is in accordance with the guidelines that have been laid down by the central government. The central government would have laid down certain rules and guidelines with regard to management of our protected areas. This would be approved by the National Board for Wildlife. So the Chief Wildlife Wardens, they will be bound to follow these rules and guidelines laid down by the center, and they will also get additional powers to effectively manage our protected areas. So that is why this is an important amendment, and it also provides for recognition of the special areas where you have tribal communities dwelling in forest areas. For example, scheduled areas of 5th schedule, where you have tribal communities, or those areas where Forest Rights Act of 2006 is applicable, right? For certain tribal communities and forest dwelling communities, their forest rights, their traditional rights are recognized through the Forest Rights Act. So these are special areas which are part of our protected areas. So the special circumstances over here, the rights of tribal communities, they are given recognition, and for better management of these special areas, adequate provisions are being made through the amendment bill. And finally, the amendment bill provides for implementation of conservation reserves. See, previously we discussed that the Act provides for establishment of conservation reserves, but it was never taken forward by the states and the central government, right? Previously I mentioned that the state government was given the power under the existing Act to establish conservation reserves around protected areas, right? To create a buffer if there were any important zones, important ecosystems around sanctuaries and national parks, state governments could have set up these conservation reserves. But previously, not much effort was made in this regard. So right now, both center and state are being given additional powers to establish conservation reserves. Going forward, it's not just the state, even central governments can go ahead and set up conservation reserves. Then finally, it also deals with captive animals. It's a minor provision. If you are in possession of a captive animal, if you can surrender it back to the government will take ownership of the captive animal. The idea is to bring back the wild animals which are in captivity and introduce them back into wildlife. And finally, it provides for renewed penalties and more strict punishment to those who offend the law or those who violate the provisions of the law. So these are the key amendments that have been proposed. They have been reviewed by a parliamentary standing committee, and very soon the parliament might enact the amendment bill. It is in this context that we took up the discussion, because there could be a mains question or even a prelims question on whatever we discussed regarding the Wildlife Protection Act of 1972. So this brings our discussion to an end, and I would like to take a look at some questions that you have asked. So what type of questions will be asked from this topic? See, there are plenty of areas from this topic where questions can be picked. The features of Wildlife Protection Act of India can be a question. The constitutional framework we discussed, Article 21, 48A, the fundamental duty. So that can be a question regarding protection of wildlife and protection of forests. Then forests being shifted to concurrent list through the 42nd Amendment Act. That could be a prelims question, right? Then National Board for Wildlife, its composition, who is the chairperson, what is its role and functions, the NTCA, all these are very, very important topics. Also, wildlife sanctuaries and national parks, their differences, right? Who has the authority to set up these protected areas? Which are the Schedule 1 animals? Or what's the difference between Schedule 1 and Schedule 2? So such basic topics could be very important for your prelims. And from a mains point of view, you should be able to understand the significance of this act. What role has it played in the protection of India's wildlife? Next, what is a buffer zone? See, when it comes to conservation and protection of national parks and even biosphere reserves and even tiger reserves, this concept called the core buffer zone model is followed. With regard to conservation, a core area is identified where you have the richest and the highest presence and density of endangered species and biodiversity, and the core areas are given maximum protection within a protected area. A buffer zone is present around the core area. The core area is lies at the very heart of the protected area. It has the richest biodiversity and it requires the highest protection. Around the core area, a buffer zone will be set up where limited human activities will be allowed. In core areas, human activities will be entirely prohibited. Even tribal communities will be shifted out. So within the buffer zone, it gives the space for the authorities to manage or balance the rights of the communities and the need for protecting the environment. So that is a buffer zone. Next, a student is asking, is it enough knowledge with regard to Wildlife Protection Act? Definitely yes. What we have discussed is more than enough. What is IUCN Red List? See, IUCN is a global organization that maintains a list of threatened species, right? So it maintains a list called the Red List, which is an entirely separate discussion. And the threatened species of animals, birds and plants are listed on the Red List. It has various categories under which the species are categorized, and that is the IUCN Red List. Okay, so these are the questions that were there for today. I hope it was a fruitful discussion. If you liked it, do press the like button, share the video with fellow aspirants, and don't forget to subscribe to our channel. So that is it for today. Thanks for watching.